Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at an important book which I find very, very helpful. We'll talk about it before. We've reviewed it before, but we're going to have a look at the new edition, which is the third edition. It's on commercial property litigation. It's been written by two people, James Fieldsend and Paul McAndrews. Now, Elizabeth has been the lead writer on this review. It comes to us now from LexisNexis, which is obviously part of Jordan's, as was. Now, the title we've given our review is The Definitive Text for Property Litigators, now in a new third edition. Now, before we talk a little bit about the book and our review, let's look at it first of all. There it is. It's a hardback. There's the front, and then there's the spine. And modesty doesn't permit me from not mentioning that we got a nice quote from ourselves on the previous edition. You've got the contents. And what we said about the previous edition was a reliable source of reference should be part of the professional library of every lawyer advising or acting in landlord and tenant matters, an essential purchase. And we feel the same. I mean, it's been updated by the two authors, but we feel the same way as we did before about this. It's a first-class book. Now, looking at the back, there is a CD-ROM, which you can see at the back there. Now, just go at the back, you can see the actual index by paragraph numbering. It's quite a detailed index, which is useful because there's a lot that needs to be covered. You can see the index starting there. And there are a lot of appendices, very helpful, 34 of them, which is one of the reasons why you've got the CD-ROM, of course, because that will give you a lot of precedence. Now, at the front, there is the front page. You can see James Fieldsend comes from Tanfield Chambers, and Paul McAndrews is a consultant with Goodman Derrick. Now, there's the detail about the book there, and I just want to show you the dedication, which I think is very important. I've not mentioned it in the review, but I'm showing it there, which I think is an important thing to mention. Then there's a preface to the third edition, which is worth reading because it explains some of the changes that have taken place. It starts off, in the last 2 years, the Supreme Court has handed down 3 important decisions relevant to commercial property practitioners concerning interpretation of commercial contracts and the implication of terms. And then it goes into detail, and they set it out for you. So that will give you some idea of what you're looking for. The law is stated as at the 4th of April 2017, and I'm recording this in the autumn. There is the content section. It's various chapters. It's quite a detailed content section, which I think is quite helpful, and it runs all the way through. And then we get up to chapter 15. ADR is the end. Then we've got the appendices, and there are a substantial number. You can see running into pages. And then after that we have the tables of cases. And not to be surprised, we've then got the statutes. That must have those. Then this SIs, statutory instruments. And then we get into the book itself. You see structure, right at the beginning, chapter 1, notices. See the paragraph numbering at the side, and you see the footnotes. So you've got a standard structure, very much in keeping with the house style of Lexis and of Jordan's. Lease renewals mentioned there, for instance, in there. So you see, you've got just taking an example, you've got a lot of stuff. As I say, it's a heavy book. I'll make sure it doesn't fall over. It probably will do, but there we are. Now, let me talk about what we think about the book, because, as I say, we've reviewed it several times now. It's a perennial favourite, I think, with us, because this is what we say for corporate lawyers, or indeed any lawyer advising or acting on landlord and tenant matters, specifically for commercial property. This publication by LexisNexis of the third and latest edition of Commercial Property Litigation is welcome news, and certainly very pleased to see its arrival. Scholarly, thorough and precise, the two authors, James Fieldsend and Paul McAndrews, elucidate and examine the complexities of this broad-based subject matter in precise detail. Given the massive scope of the subject, this is an immense help, I think, to hard-pressed practitioners, and as in previous editions, the authors have produced a logically organised text which certainly deserves to be known as the definitive work of reference for commercial property litigators. hence our quote, which you very kindly put on the back of the book. Now, the book covers all pertinent aspects of the practice and procedure involved, with the emphasis on the issues and problems commonly encountered by property litigators. And I think, again, that's useful for the practitioner and also, of course, for the unrepresented party. Now, the first of its 15 chapters, for example, deals in detail with notices, which I showed you right at the beginning of chapter 1. Then it goes to contractual notices, rent review notices, notices to quit, and so forth. The chapters following include such issues, depending on what you're looking for, as lease renewal, surrender, forfeiture, commercial rent arrears, ADR right at the back, of course, and much more. Now, the book also features no less than 24 appendices, which include notices, of course, plus the various responses to said notices, claim forms, draft orders of practice direction, claim for forfeiture, and a defence to the said claim. And it's important to note, therefore, as I've indicated at the back, you've got the CD-ROM, which provides convenient access to time-saving precedent materials. And in the new edition, as you would expect, there is much new material which can't really be gone into in a lot of detail. I can only summarise it for you. Much discussion, for instance, is devoted to 3 important decisions which are mentioned right at the beginning in the preface by the Supreme Court, and that's Arnold and Britton, Wood and Short-Term Direct, and Wood and Capita Insurance. Again, I think those are covered in a neat statement right at the beginning of the preface. And another case, Marks and Spencer and BNP Paribas. This is the Jersey branch. In that case, the court made clear that the construction of a commercial contract and the implication of terms, to summarise, are, quote, distinct and separate processes governed by different rules. And I think certainly in legal terms we would understand that. Other issues either new to this edition or those which have undergone certain changes include the following: the avoidance of windfall dilapidations and various matters pertaining to mixed-use properties detailed in the book at chapter 14. Now, property litigators keen to keep up to date with the latest developments will find that this book is an essential tool, especially as it provides any number of research resources and references. So effectively it is really a one-stop shop for you without having to go any further. There's an especially lengthy table of cases at the beginning, together with, of course, statutes and SIs, and extensive footnoting. And the index and detailed table of contents, I think, do assist the navigation of the book, because it's quite a big book. So for commercial landlords and developers, as well as their legal advisors, and basically people who need to have some knowledge of this area, legal knowledge of this area, this book's a must-have purchase. Now, as I say, the authors have endeavoured to state the law as it was at the 4th of April 2017, and I'm recording this in the autumn of 2017. We're obviously going to have a lot of changes in this country in the next couple of years, but I'm sure this book will be invaluable for the next 2 to 3 years at the very least, if not longer. Here it is again, the front, side, and then the back, our quote and the details there. It runs to just over 600 pages. In fact, the total is not 24, it's actually 34. I think I said 24 appendices, but it isn't. It's actually 34 appendices, the last one being defence to claim for forfeiture, so forth. But you do have here, again, stuff which I would find extremely helpful. You've got the pre-action conduct, for instance. You do have an awful lot of stuff which would be great help to counsel. So thank you very much to James and Paul for producing this book, and of course to Lexis for taking it over from Jordan's, because I believe it first appeared as a Jordan title, but Jordan, of course, have been taken over by Lexis. So a big thank you to all concerned. Do look at our review on the web and in the journals, and once again, it's a great help to all of us to have this book, so very grateful to you for the time you've put in. Thank you. Bye-bye.